You get served, you call us right away because we'll get you in our office, walk you through this process, talk about those allegations, get ourselves prepared for the hearing, get our client prepared to testify. Mm-hmm. You know, I always bring my client in to get their testimony, kind of walk them through what my questions are going to be. I always give them tips and kind of give them a little bit of a preview of what a cross-examination will look like, because each party will be subjected to petitioner and respondent will both be subjected to cross-examination. It's paramount when you walk into a courtroom for a hearing, for anything. It's paramount that you are as prepared as you possibly can be. It's paramount and critical that your client is as prepared as he or she can possibly be. They're going to be more comfortable. They're going to come off more credible. When they are comfortable, you know, you're going to come off as more authentic, more genuine, versus, you know, it's okay to be nervous. Everyone is nervous when they walk into court. Yeah. But it's our job, my job as their lawyer, is that they are as prepared as they possibly can be. You know, that they are ready for cross-examination because I've walked them through what that's going to look like.
Is there a timeline of which, when you're served, can I call the person that filed the order of protection? At which point I'm served with it, can I call them?
Call the person who...
The person that ordered
No,
the
I mean,
petitioner. Because
you're going to have a temporary order and they're saying not to communicate or contact.
Even if you don't look at it?
Yes. As soon as you're served, you're put on notice.
As soon as it's set in front of you.
Once that's served to you, whether you looked at it, threw it away, burned it, you're on notice, and that's your responsibility. And at that point, you know, I get that a lot where folks want to call that person to resolve it. Well, once you're served, to do what you just said, to call, you know, maybe it's your ex-girlfriend. I want to just call her and say, come on, let's just put all this aside. I'm really sorry now. I won't have any more. No, that's a violation. You can be arrested for that. Whether you read it or not, it's your responsibility because you were put on notice. You were officially served.
And I'll let Steve correct me if I'm wrong, but I think the majority, and I don't know the percentage, are served as ex parte, which means they've only heard from one side. But that means it's in effect as soon as you are served until they hear from both parties at a hearing. So I don't know what percentage are served with ex partes.
Yeah,
it is effective immediately upon being served.
Correct. And there's two ways, without getting too into the weeds on this, there's two. You could have an ex parte order. That's what Chris said, an immediate order saying no communication, no contact, can't be within 500,000 feet. Or the court can simply issue you a summons to appear for the hearing and didn't issue any temporary orders. In that case, you could technically call the petitioner. I wouldn't suggest doing that, especially with pending litigation. It's my advice, if you are served, whether it's BS or whether it's truthful, whether it's by an ex parte or by some notice of hearing or summons, you call an attorney. Get yourself ready for the hearing and start getting the wheels in motion on that.